And this just in, we're getting our first look today at Luigi Mangione inside court for a hearing in his New York State murder case. He's the man accused of killing United Healthcare CEO Brian Thompson last year. Attorneys for Mangione are trying to get key evidence like his diary entries tossed from his state murder case. CNN's Kara Scannell filed this report just before heading into court.
Luigi Mangione is back in court this morning as his lawyers try to get some key evidence in this case thrown out. The focus is when Mangione was approached by law enforcement at a McDonald's in Altoona, Pennsylvania. It's there that his lawyers argue his constitutional rights were violated. They say the Altoona police searched his backpack illegally because they didn't have a warrant. They also say they violated his rights by asking him questions without reading his Miranda rights, that is his right to remain silent. So what his lawyers want to keep out of this case and away from his jury are those contents that were found in the backpack: a gun, a silencer, and a notebook that had Mangione's handwriting samples in there. The prosecutors say that that was his manifesto and explained his motive for why he allegedly shot and killed United Healthcare CEO Brian Thompson last December. Mangione wrote in that notebook, "Whack the CEO at annual parasitic bean counter convention." He also wrote, "It conveys a greedy bastard that had it coming." Mangione's lawyers also want to keep away from a jury a statement that he initially gave to law enforcement when he identified himself as Mark Rosario. That's the name of the person who rented a hostel room that authorities say the shooter stayed in just days before United Healthcare CEO Brian Thompson was gunned down. Prosecutors say that nothing improper happened. They are expected to call as many as 24 witnesses. Mangione will be in court. He's been given permission by the judge to wear a suit. He's asked to have one hand unshackled so he can take notes. The judge has not yet ruled on that, but this hearing could last several days. Wolf?
All right, Kara Scannell, I know you're going to be heading into that courtroom, and we'll be checking back with you often. Thank you very, very much. I want to bring in CNN legal analyst Joey Jackson right now. Joey, break down what the defense is arguing for us right now. Why are they trying to get this evidence thrown out?
So, Wolf, prior to any trial, you have what are called pretrial proceedings. At those pretrial proceedings, the prosecution has to establish that any evidence seized was seized properly, that there was probable cause underlying any seizure. Here, the issue in dispute is a backpack. Why is the defense trying to keep it out? Because it has damning evidence and information. As Kara Scannell just laid out, you have a backpack that has a gun, it has the silencer, it has the manifesto, quote unquote, which gives the real intention behind this killing of the healthcare executive, and so it's very damning if the jury would see it, in addition to his identification. They are alleging that as a defense that it was an improper search, that the bag was not in his possession technically. It was on a table that was nearby. It posed no danger to them. They should have gotten a warrant prior to going into the backpack, and as a result of not getting a warrant, it would be illegal and improper. And the remedy, in the event the judge determines that the bag was seized and opened and looked into illegally, the remedy is to exclude that from the jury's view. The jury is not there today. It's just the judge, and the prosecutors have to lay out the information to establish that that seizure of the bag and anything associated with it was done properly. Now, the prosecution will argue that they had an emergency circumstance. It could have been a bomb or something else in that backpack. In addition, the prosecution will argue that it would have inevitably been discovered, meaning it would have been taken back, it would have been inventoried, etc. But the defense is alleging that, hey, in the event that happened, they still would have needed to get a warrant, which they subsequently did several hours later. The defense says, hey, it's too late. You open up that backpack, it's not coming in. Final point, Wolf, and that is that's called a MAP hearing. Another pretrial proceeding is called a Huntley hearing. That is to determine whether any statements that he made, that is Mr. Mangione, were in fact made properly. Now, if you're going to question a suspect, we've all seen this, you have to issue them their Miranda warnings, but only if it's a custodial interrogation. That means they're in custody and they are being interrogated. Here, the defense alleges they should not have spoken to him at all, such that they would elicit information as to a false name or anything else, and that the statement additionally should be thrown out. And so all these witnesses are going to establish, the prosecution hopes, the propriety and legality of the search of the bag, the propriety and legality of the statements, and in the event they do, those statements will be shown to the jury. In the event they don't, the jury will not see them, they will be concealed, and the prosecution must go forward with other evidence, but not that evidence that was in the bag.
And that evidence is obviously very, very important. The hearing is expected to last several days now. Tell us why.
Well, generally, these hearings do not last several days. I think this case is a case like none other. Generally, these hearings last a day. Sometimes they go on more. But here, you have various jurisdictions. You have the Pennsylvania jurisdiction. I think we'll hear testimony as to the officers who initially approached him, where he was, why they searched the bag, what he was doing, why they felt the necessity of doing that. And so they have to establish it as the prosecution that the search was done with probable cause because they want that evidence and information in. Now, you don't have to show proof beyond a reasonable doubt. It's not that type of hearing, but you certainly have to give enough to the judge to show that it was proper, it was authentic, it was lawful, and it was predicated upon probable cause. In the absence of that, the judge will exclude, that is, prevent the jury from seeing this, but the trial will still move forward.
And very quickly, before I let you go, Joey, does the prosecution acknowledge they never told Mangione he has a right to remain silent?
Indeed, they do. But however, there are other arguments, even though they eventually did. But at the time that they were making an accusation towards him, if it's a custodial interrogation, doesn't mean you're in cuffs. But if you're not free to leave and they're asking questions that could incriminate you, you have to give Miranda. However, if you're simply investigating a case and not really questioning him such that you're eliciting guilty statements, you don't. And so there's a fine line with respect to investigatory information being supplied and incriminatory, meaning you're looking for evidence to incriminate them. The police say we just needed to know what the lay of the land was, and that was the basis upon which we asked those questions.
Interesting. All right, Joey, thank you very, very much.
Let's get some expert insight from criminal defense attorney Robert Bianchi, who's also a former homicide prosecutor. Bob, thanks so much for being with us. I wonder if you think Mangione's lawyers have a strong argument to make for this evidence to be tossed.
Boris, I know that people tend to do like balls and strikes here in terms of where your ideology is, but I look at it as an attorney, and from the beginning of this, I've been extremely concerned about the constitutionality of this search. Now, we don't know a lot of facts, but I've been on a lot of murder crime scenes where I see over anxious and understandably well-meaning police officers in a heightened situation. They're not thinking it through. Maybe they're not in contact with their prosecutors or lawyers, and it's natural and instinct to just kind of open the bag and take a look-see to see what's inside. It happens all the time. And the defense is essentially saying here, the Constitution requires that every search be done pursuant to a warrant, a judicial warrant. And there are some exceptions to that warrant requirement. And the defense is saying there are no exceptions here. For example, if somebody consents to having the backpack looked into, then that's an exception to the warrant requirement. So I hope that I'm not going to hear that they just grabbed it. They were excited. They didn't have probable cause. They weren't in fear. They weren't in danger. He was secured, and they just looked inside and then afterwards got the warrant. In New York state law, that may be a problem. You have an easier chance under federal search and seizure law.
It sounds like you think that if this evidence is tossed, the state is going to have a hard time finding him guilty.
Wow, this would be a massive blow to the government. But then again, let's keep in mind here, we have both state prosecutions and federal prosecutions, and what may be suppressed in state court, again, federal court's more accommodating the prosecutors. But the evidence in that backpack, even though you don't need motive to prove a homicide case, shows premeditation. It's got the weapon. The weapon is connected to the victim in the case. It shows a cold, calculated, premeditated murder. It is the lock that any prosecutor wants. Otherwise, they got to go without that evidence on a circumstantial case that's much weaker. In that case, it's going to be interesting to see, really, to be honest with you, Boris, when the law enforcement authorities get together, there's got to be a discussion. Is it better to prosecute them federally first or better to prosecute them state-wise? Now, if there's a suppression of the evidence in state court, you can bet the federal case is going to take precedence.
I also wonder about the other evidence his attorneys are trying to suppress, and it involves statements that he made while at that McDonald's in Western Pennsylvania. His attorneys are essentially arguing that officers didn't advise him of his Miranda rights the right way when they began questioning him. How do you see that playing out?
Not as crucial as the search and seizure, for sure, because that evidence in that backpack is the lock. But of course, if the prosecution wants to use his statements, Miranda requires that you, one, be in custody, or the person would have reasonably believed they were not free to leave. That's element number one, and that they're asked a question. So the issue in this case is going to be, and we just don't know the facts yet, was he in fact under the reasonable belief that he was not free to leave, and was he asked the question without being given his Miranda warnings? And if that happens, then any statements that he made up until the time he gave his Miranda warnings is subject to being suppressed by the court. But again, in this particular case, if I were a prosecutor and things were on the line, I'd rather lose on the Miranda side of the case and make sure I win on the search and seizure side, because that's where the case is going to be won by prosecutors. What's in that backpack?
Bob Bianchi, appreciate the analysis. Thanks so much for joining us.